Hi, my name is Shoshana Kehoe-Ehlers, and I'm coming to you from Olympia, Washington, from the Washington State Office of Public Defense. Um, I'm here to present on the Washington State Revised Code Statute 7109, also known as the Sexually Violent Predator Statute. So I am going to be picking up where Bob Berkowitz, who was just before me, ended. And Bob did a really good job explaining the evolution of this law in its early days when public defenders were challenging it, because it is really, it's illogical to have to, in a sense, be resentenced to a term in a hospital. And the way it was back then, all the way probably up until about 2010, 2011, is you either won your initial commitment trial, which is a big, big deal. Lots of work had to go into it. Or if you were committed by a judge or jury, you would then, there was really no way out. So you would just die there. And that honestly became a huge fear of a lot of patients as they aged there, that this was where they were going to die. And that's because, as Bob said, this was much more of a correctional punitive system method of dealing with folks that they thought were 51% likely, more likely than not, to commit a sex offense in the future. And as you can imagine, the research and everything that has evolved around then has been a little kind of questionable, because trying to predict what somebody is going to do in the future it's impossible. I mean, it just is. So once it was clear that after the cases had run through all of the different court systems, state court, federal court, the US Supreme Court, it was clear that this was going to have to be a statute that was going to have to become workable. What was going on at around 2007, 2008 is we were starting to see either private, what's called, after a person is committed and they were doing treatment, and the treatment team started seeing that, they could probably be out in the community, or not probably, they could be out in the community without there being a significant risk that they would reoffend, and that they could be out in the community with adequate protection factors for themselves and for the community. The problem is that there was no housing, and not just no housing, but that there was no infrastructure around what this individual was going to do in the community. So as Bob had mentioned, under a federal decree, because the Special Commitment Center was not providing treatment or avenue to leave the Special Commitment Center and actually make it out, then they became under federal decree to improve that. And part of that was to build 2 secure community transition facilities. And that's what Bob was talking about, like halfway houses. One is on the island, the McNeil Island, where the Special Commitment Center is. And one is in King County in the industrial district, also called Soto, which is where, where the sports, Seattle Mariners, and where that whole area is. It's pretty industrial. And they're a lot more than just halfway houses. There's barbed wire around them. There are cameras everywhere. Individuals cannot leave without permission, and they have to be able to do kind of point to point, where they call their community corrections officer, and then when they get to their destination, call them again, and when they get back to the facility, call them again. And that's about all they could do. Was when you're in the SCTF, you're able to go see your community treatment provider. And if you're, fortunate enough, you could maybe also do some trade school, some community college, or work, really. That's what, for those that are able to, for being able to secure employment so that they can, be able to take care of themselves once the civil commitment process is finished. So let me just back up a little bit. So that's how the Pierce and King County SCTFs happen. So there was just those two. But these individuals come from all 39 counties in Washington state. And I think a lot of that had to do with, yes, they had to build these SCTFs, but there wasn't a feeling that this was actually going to go any further than that. Although we did start to see in 2008, 2009, 2010, individuals being able to be released to private residences. So essentially what that meant is if the individual had family and they would be able to go back and live with them, that would work. But other than that, there was nothing where the individual could go other than the SCTF. So my office, the State Office of Public Defense, became involved in this back in 2012, so 10 years ago. In Washington state, as you may know, public defense is decentralized. It's not a state system. It's county by county, city by city. And so, being able to ensure that the individuals who were being represented by defenders who had the background in civil commitment was really tough. Our bigger counties like Spokane, Snohomish, Pierce, King, they had a fairly robust public defense system that was able to, understandably, take on these cases. But outside of that, most of the time, these cases were assigned to an individual that had a regular general practice caseload or a criminal defense caseload. And so while they were doing things that were on much quicker timelines in 7109, these cases sort of hit the back burner. And they were assigned just, the most way that cases are assigned around Washington state in the non-bigger counties is a judge might assign them, or some sort of small, public defender office would assign them, but not looking at to see if they had the requisite experience. And so what we were finding is when OPD took over in 2012, is that there looked like there was probably about 40 to 50 individuals that had been there for over 10 years at the Special Commitment Center and had yet to receive their first initial commitment trial. So once probable cause was found, they were sent to the SCC. They sat there for sometimes a decade because of what Bob had shared with and the CLE, that the issues were so significant and they were litigating constitutional issues that things wouldn't move at any kind of reasonable pace. Plus, the Special Commitment Center was not in the business of treatment and trying to provide the treatment environment that the individuals needed for them to be able to begin the step down process into the community. Understandably, there was not a lot of support for this. DSHS is an enormous agency. It was the legislature that came up with this law. And so clearly they wanted to be able to, hang on to these folks because of the fear that the public had. But once the federal monitoring started, it became clear that you just can't neglect these individuals because they're there for a purpose. And if they don't meet what's called the criteria, which is also the statutory definition of what's called a sexually violent predator, then they can no longer be held. They can no longer be held in total confinement. They can no longer be held on a conditional release, which is also known as a less restrictive alternative. And the reason they call it less restrictive alternative is because the total confinement center, which is on the island, is a complete lockdown. Less restrictive, which is also something that's used in other areas of our mental health system, such as Involuntary Treatment Act, not guilty by reason of insanity individuals, that you have to be able to have a path out. That's basically how all of these statutes are allowed to be constitutional, especially when it comes to 7109, because you have already served your prison or your jail term. So there just seemed to be kind of a lackadaisical approach to all of this. Now, when OPD took over, we were able to contract with a group of contractors across the state that had expertise in this area. And we primarily made it that you had to exclusively practice this in 7109. That significantly changed things in the first few years because the attorneys, social workers, legal assistants, investigators were able to push cases that had been sitting there for decades out, getting them moving, having them dismissed if there really wasn't the criteria, or if they had been in treatment for a while, having them petition for an LRA. In Washington State, the way the statute is the secretary, the hospital, can recommend that the person either, one, just be unconditionally discharged because they no longer meet the definition, or two, they meet the definition, but it's within their best interests to be on a less restrictive alternative, and there are adequate public safety and measures to protect the community. Once that happens, then you can start petitioning for an LRA, and that's when the litigation starts. Because in the beginning, the state, there's two state actors here. There is the Special Commitment Center, which falls under Behavioral Health Administration, which falls under DSHS. And then there's the state that does the prosecutions of these civil commitment cases, and that's handled by the Attorney General's office, except in King County, where it's handled by the King County Prosecutor's Office. And the reason for that is that all the counties, if they chose to, they could prosecute these civil commitments. But because they are such a resource-heavy process and requires expertise in the area of risk actuarials, peer review studies, all sorts of stuff, statistics, understanding the DSM-5, being able to read peer-reviewed studies, being able to score risk actuarial tools and cross-examine experts who have a ton of background in this area to be able to do that. So once the petition was granted, or once the case was set for trial, then the process really started. Do we have a sex offender treatment provider that's going to be appropriate for this individual? What about housing? What about, location? What about making sure that victims and other types of neighborhoods and things like that are not going to become too much of a challenge for the individual to live in. So a lot of that went on for several years once something was set for trial. Majority of the time, the attorney generals and the defense attorneys would negotiate a less restrictive alternative, but it took an enormous amount of work because the statute said that the defense was entirely responsible for putting an LRA together, which means we had to find the housing, we had to find the sex offender treatment provider, all of this stuff. Now, because defense, we don't have any access to paying for the housing, that is handled by DSHS. And because we don't know where everybody resides and what's going on in that area, we could only do it case by case. So what ended up happening is, well, let me back up one thing. So the early days of when OPD took over and the defense attorneys were really litigating these cases hard, things started moving a lot faster, I think, than the legislators wanted and the prosecutors and the community wanted. But it was something that had been a backlog for over a decade. So the issue was being forced. These individuals were moving into the community. They had to move into the community. They had orders saying that they should be released. And sometimes these people were just sitting there, especially the individuals with intellectual disabilities, traumatic brain injuries, dementia, high acuity mental health, wheelchair users. None of them were able to get adequate housing and other types of services to be able to be successful on an LRA. That's when Disability Rights Washington entered. 2014, they started investigating. In 2015 and 2016 was when, actually 2015 was when the articles started coming out talking about how poorly these residents were being treated, how they were being warehoused despite the fact that they're not supposed to be. People were dying on the island because they live on an island as opposed to close to any hospitals. There was never adequate medical care. There's still a lot of problems with that. The only way you could get off if you had some sort of major medical issue was to be helicoptered off. It also was costing up to $200,000 a year to house these individuals. Because again, they're on an island. Everybody has to take a ferry out to the island, including defense attorneys. And the staff that work out there, they are not compensated for their transportation to get out there and back, only for the time that they're on the island. As far as I know, Washington State's the only one to have a special commitment center like this on an island, which makes it exceedingly difficult. It puts up a lot of barriers, and it just makes it difficult to be able to work with the individuals and ensure that they're doing okay because it's such a trek to go see them. So after Disability Rights Washington filed a complaint, the Special Commitment Center quickly entered into a federal settlement agreement, primarily to ensure that there's a high acuity wing and that there's conditional release housing, a pathway out for individuals with disabilities. This was really starting to kind of help pick things up, and we started seeing movement. But then, of course, with movement, the counties that had these less restrictive alternatives, housing and infrastructure, were very few. It was just Pierce, King, a little bit, not much, Snohomish County. They were the only ones with housing. And it made sense because the Pierce County Secure Community Transition Facility and the Total Confinement Facility is in Pierce County. They have the infrastructure. King County as well, that special commitment, that Secure Community Transition Facility, it's hard to do much of anything since it's in an industrial district. So what started happening is the attorneys started just going directly for community LRAs, less restrictive alternatives because the statute permits that. And so as of this point, I think we have like well over 70 individuals in the community. There's a total of 230 plus individuals under the jurisdiction of 7109. So as you can see in the last decade, the system has really moved to getting people into the community as quickly as possible. Now, for many of these individuals, that can't happen quickly, but there are things like adult family homes that are really providing the care that those individuals are going to need, because they're always going to need to have some type of round-the-clock care. But the other individuals are really going to benefit from the step-down process, because as you can imagine, after they've served a long prison term, it's been decades since they've been out in the world. Many don't know how to operate a cell phone. Things have really, really changed. And it's scary because you kind of have a target on your back. You do have a target on your back when you are a sex offender, when you're a level 3 sex offender, which is the highest level in Washington state, and when you have the label of a sexually violent predator. Now, back in the day, before indeterminate sentencing, which is something that Bob mentioned, and I think that started in 2002, the folks that you were getting in the 7109 were not necessarily the folks that you see now. There were individuals that had committed serial offenses. It was less a mental health issue and more of a mental disorder, like psychopathy. I mean, not psychopathy. Psychopathy and antisocial personality. But as the indeterminate sentencing law caught those individuals are now held back in prison and DOC and become part of the jurisdiction of the Indeterminate Sentencing Review Board, which is sort of took over what our parole board is. So you have to serve when you're on the inside in the prison, you have to serve at least, generally they hold you until your max date. But those individuals are often the ones that they're not so much dealing with mental health as dealing, I think, with much more significant public safety issues. So indeterminate sentencing has taken that population out, and a lot of who you see now in 7109 are individuals with disabilities. You also see young people, very young people, who essentially from day one, were in foster care or in juvenile rehabilitation. Just things are so upside down. So as these people are beginning to get out in 2017, the issue of where these people were going to go became a huge issue for legislators and the community. There was a statutory amendment that said that you had to try to go back to your county of commitment, which is also the county where your underlying conviction was. This presents all sorts of problems because there's only a handful of counties that have resources necessary for individuals to be conditionally released. Also because of victims, all sorts of stuff. Many, many, many counties in Washington state don't have any kind of infrastructure. Let's see, but I guess to say so the county of commitment issue, because Pierce County was getting most of the individuals that were coming from all across the state, excuse me. And they were really upset about it, understandably. So there was an amendment done that you need to try to get it in the county of commitment. Within a year or two, it was clear that was not working. And so in 2019, a number of interested party stakeholders came together: Disability Rights Washington, prosecutors, attorney generals, legislators, defenders, sex offender treatment providers, Special Commitment Center, Yeah, you name it, they were there. So we worked for several years to try to get at how is this going to work? And what came out of it was in 2021, what came out was we're going to have a fair share standard, not a county of commitment, which means the individual goes to, if they can go back to their county of commitment, fantastic. If they can't, then they need to go to a county that has the appropriate services for that individual. And at the time, several years ago, like I said, there were only a handful of counties that had these resources. And so the legislature and the other interested parties started to understand that building the infrastructure needed to happen through DSHS, the Special Commitment Center, because they have the resources, they have the funding, and they have the ability to take a look and see where are people being placed. So the fair share thing has to do with, for example, in Kitsap County, that county has approximately 30 individuals that are under the 7109 jurisdiction. So that means they should be able to take back 30 individuals through less restrictive alternatives or unconditional discharge. Doesn't have to be the same Kitsap County individuals, just needs to be somewhat proportional. So that is why there was a big shift. And it's only been a couple of years that this has been going on. In fact, it's so new that in 2021, the Sex Offender Policy Board, Washington Sex Offender Policy Board, was directed by the legislature to really study this issue. The Sex Offender Policy Board has all of the interested party and stakeholders already present to take a look at this issue. And then a number of individuals involved in 7109 were permitted to participate. And so finally, I think it was not this past session, 2021, yeah, at the end, a statute came out that changed things where defenders still have a right to petition for an LRA even if the state doesn't agree. And, needs to propose something. And if the Special Commitment Center can't come back with something equal to the LRA plan that has been designed by defense, then the court will consider defenses. But if the Special Commitment Center can provide them an LRA after 90 days after the petition's been filed by the defender, then both plans will be looked at. Right now, the Special Commitment Center is really struggling with housing. They have attempted to set up a secure community transitional facility in Snohomish County. They have attempted to open an adult family home in Thurston County. And what's happening is because the statute from a year and a half ago that went into effect has limitations that say that any housing cannot be within 500 feet of a daycare center. This means even a home daycare center where there's one individual there would rule out the individual being there. And zoning, so having secure community transition facility type housing along with adult family homes. They were starting to be zoned out because that one provision in the statute allowed the counties to kind of take over, which is not what's supposed to happen. The state is supposed to have total control over this so that this doesn't happen. So the Sex Offender Policy Board is submitting another report to the legislature where all of the 7109 parties are on board with changing that provision, because otherwise there will not be able to be any type of actual housing, and housing that's not, out in the boondocks. We need to have it so that the individual can have a worthwhile life. They can be out there, they can be cared for, they can access services, and they can be seen instead of being tucked away in some house that's miles and miles away from any kind of you know, activity and things like that. So that's what the new system is. And one of the challenges that we're also finding, as I think we're finding in many areas, is that the sex offender treatment providers who provide this care in the community, they're very well experienced and gifted, so much better than what's provided on the island. But there's very few of them, and they have increasingly reached that point where they've retired, and there's not newer ones ready to fill in those holes. A lot because you have to do a lot of special licensing. It's expensive. There's a lot of hours you have to do that are not compensated for your training. And you have to be willing to deal with the headache of working with Department of Corrections, DSHS, BHA. I mean, it's a adversarial job that many SOTPs don't want to be involved in. The compensation has been raised. It's still not what you can get in the private sector. So that's become a huge issue as well. I guess how I'd like to maybe kind of bring this around is an enormous amount of work was done once we got the right defenders. And once the defenders were able to really work these cases, then you had our partner, Disability Rights Washington. And I say they are our partner because dealing with sexually violent predator issues with the legislature and the community, as you can imagine, is not popular. But through the lens that these individuals have disabilities and that they're not getting the adequate treatment and that they have a right to that and that they're just lingering out there on the island and they're not even being accommodated in any kind of way. And in fact, they're being treated, I think, in a malpractice kind of way. And everybody takes Disability Rights Washington seriously in a way that they don't take public defenders. I don't know why, but we're very happy to have them. And so they have been a huge partner in this. They monitor it. The Sex Offender Policy Board is monitoring it. And then, of course, the defense attorneys. And so I think having a group of defense attorneys who are skilled in this area and don't have enormous caseloads, working with all of the stakeholders and willing to get into the rooms. And it was hard. It's been really, really hard. It's a very emotional topic. The trauma that the victims go through, that the patients, the individuals go through, and the vicarious trauma that all of us experience being a part of this. But the individuals that are involved in this, from what I can tell, are involved in this because of what this is about and trying to get individuals that have been forgotten and making sure. And let me tell you, the individuals who are getting out, they are so at a point of easy, manageable risk that it's just not what it was like before. And so with that, now we are in 10 years into this, and the legislature has requested at the Disability Rights Washington request that has directed the Washington State Office of Public Defense to come up with a proposal for the statewide administration of public defense in the area of not guilty by reason of insanity. Specifically, the statute is named 1077, and it only has to do with once the person is committed, either by stipulation or by trial. Once they are committed under the NGRI statute, they have a right to an attorney. There's a state Supreme Court case called Fletcher that came out several years ago that talks about this. And so Disability Rights Washington noticed much of what they noticed with the 7109 population, that because of Washington State's decentralized public defense system, it's all over the map how individuals get out. And also the focus is oftentimes on, if the person is getting out, the focus seems to be on what they did 20 years ago, 10 years ago, 5 years ago, not on where they're at right now and what things can be done to help mitigate risk. there are no release plans being done except by DSHS, and they barely are able to do that. We have a highly skilled forensic social work group that do release planning for these individuals, and they're able to find all of the necessary resources across the state. And so we've actually partnered with the SCC in many ways. And I think that's how sometimes this mental health system is going to improve, is if we go in there and show them what all the problems are and get this thing moving along with other partners. And the cost is enormous. And it's also a vestige from the 90s and early 2000s of mass incarceration and mass institutionalization. So we're now looking at this for the NGRI group, a similar program. And that's the kind of stuff that's starting to happen here in Washington State, where civil commitment, things that came out of the criminal system, much like what we're seeing in DOC, where folks who are needing to be resentenced because they were young when they were first sentenced, they have extraordinary disabilities, or they're just no longer a risk and need to be resentenced. So we're working on this, and I feel like the 7109 system now is, while it's unfortunate that we have to have it at all, it's at a point where you have an avenue out, and our attorneys and partners will help you move as quickly as you can. And I think this can now be shared with other areas of mental health. And so, yeah, that's what I have to say about how Washington civil commitment laws are like here where we're at. It's still a work in progress. But my work here for the last 10 years, I have to say, I actually have a lot more hope that the system can become something, at least, where maybe everybody can start in the community or close to it, so that they don't have to be locked up. And also to deal with the issues of people with disabilities, significant disabilities, and people of color being disproportionately impacted by this, because that's certainly the case. So I've enjoyed my time sharing my story about Washington State civil commitment law. There's lots of creative things that can be done with it. There's about 21 states that do 7109 civil commitment. And many other states have a lot of problems. And I think part of that is, well, actually, I don't know, but I don't know. It could be the partnerships that have been made. And that's really the only way, I think, when you're dealing with mental health and communities and criminal, like the forensic area, you got to work with everybody. But at other times, you got to litigate the crap out of it, because once people say, nope, absolutely not, juries have a very different take on it. They do. They don't like this law. They don't like the double jeopardy aspect. But they are also concerned about having these individuals out in the community. So there's a lot of safety and protective factors within this law now that weren't there before. I don't like it, but it does give a number of individuals who probably would never have made it out of prison under the indeterminate sentencing. It gives them a path out, and it gives them a lot of support. So thank you very much.